aggrieved. And in fact, we'll talk about this again in a minute. But if you look at Section 702 of the APA, it's phrased in terms of sort of a waiver of sovereign immunity. So as a person suffering legal wrong because of agency action or adversely affected or aggrieved by agency action within the meaning of a relevant statute is entitled to judicial review thereof. And then it provides that an action in the court of the United States seeking relief other than money damages and stating a claim that an agency or an officer or employee thereof acted or failed to act in an official capacity or under color of legal authority shall not be dismissed on the ground that it is against the United States or that the United States is an indispensable party. So, it's phrased as if you're injured, you can sue, and sovereign immunity doesn't kick in. So this presumption that you see discussed, and this is the same presumption that you see discussed at the heart of the decision in Bowen, the first big case that you read for today, is this understanding that, look, there's a general rule that says if you've been legally injured by something that an agency has done, you can sue them. The same thing often holds true in the state court systems. The state APAs are generally phrased in ways that hold sort of similar kind of an approach and kind of carry a general kind of waiver of sovereign immunity, allowing people to sue in the event that they've been injured by an agency actor. But oftentimes it's not quite as explicit as it is in the context of the federal APA. As we'll mention below, the federal APA is sort of a catch-all statute. If an agency's done you wrong, then you can sue them. And so that's the sort of initial presumption that you might want to start with in a case where you're trying to decide whether or not there happens to be some sort of a cause of action to sue the agency in a particular situation. Okay, so those are the main issues to talk about as far as the places that the places to begin. There is sovereign immunity, but there's also a presumption in favor of judicial review of agency action that has caused legal harm. So let's talk about the major causes of action available against the government. The primary topics of discussion in this chapter are the judicial review provisions of the APA and to a lesser degree the model state APA. The first one then is the federal APA, Section 702, that provides a cause of action for litigation against agencies that have caused legal injury. This is the primary point of discussion today. Just a couple of points worth mentioning before we get into the actual exemptions that are the main topics for later. You note, first of all, that it doesn't apply to suits for money damages. So this means that as a practical matter, if you're suing under the APA, you're suing for what amounts to injunctive relief. You want to force the agency to do something or not to do something. But that's about all you're going to get from the agency in a situation where you're suing under Section 702 of the APA. Usually you want the agency to reverse an order that it's issued against your client. You want the agency to vacate a rule. You want the agency to change the rule. These are all forcing the agency to do things that the agency wouldn't, believe that the agency is required to do under the law. But it's not saying to the agency, oh, and by the way, I want money for that as a result. And you can't do that under the APA. That's not part of the waiver of immunity that you find under the federal APA, is the idea that you can get money damages. So when it comes down to that issue then, the other thing that's worth noticing is that the APA doesn't provide a basis for assessing what the underlying legal requirements are. It doesn't tell you what the legal injury is. It starts with the assumption that there's been a legal injury. Now, it tells you, of course, the standards of review. You find that in Section 706 of the APA. But it doesn't say that the agency has to have acted in a particular manner, or it doesn't give sort of substantive content to what it is that the agency has been required to do. As a result, or I guess I should say that rather that substantive content is the thing that comes from step one, the first of those three things that we talked about, the idea of the injury. That's where you find the substantive content, the thing that it is that the agency's done wrong. The cause of action just says, if there's been wrong done, this is what you get to do. You get to sue the government. The flaws, of course, with the APA, in Section 702 of the APA, is that it doesn't apply to a range of circumstances. First of all, it only applies to agency action. And if you look at the way that an agency is defined under Section 551 of the APA, and then also under Section 701, which talks about defining agency for purposes of Chapter 7 of the APA, you see that there are, chunks of entities that are out there that are just not covered. And if those entities are simply not covered, then trying to go the route of Section 702, of course, isn't going to work. So you're going to try and find some alternative solutions. The other problem, of course, is that there are exemptions that are peppered throughout the APA that we've talked about before, and we'll talk about some more today. And so if those exemptions apply, then you're going to be out of luck. If you want money damages, you're out of luck. Section 702 is a useful catch-all, a gap-filling statute, as one D.C. Circuit case described it, but at the same time, it is not a perfect gap-filling statute, and it leaves holes. So you always want to look for alternatives in addition to the APA. I should say that in state law, the equivalent to Section 702 of the APA is the provisions in the Oregon APA, so ORS 183.400, that talks about review of rules, and then ORS 183.482 and .484 that talk about the review of orders in contested cases and orders in other than contested cases, respectively. All of those provide a cause of action for relief against the state, but it has similar gaps as you have under Section 702 of the federal APA, in the sense that it doesn't provide for money damages, and it's limited to certain types of review and has very specific mechanisms that you have to go through, and it doesn't cover all possible governmental entities that are out there. So the first provision is that you've got then the APA, or the general review provisions of the federal or the state APA. The second place you might look for causes of action are just the specific statutes. You may very well find in a particular statute, in a particular substantive statute, the Social Security Act, the Clean Air Act, the Clean Water Act, almost any of those provisions, something that is going to tell you that if the administrator of the Social Security Administration has done something that you don't like, then you can sue them. That is the creation of a cause of action within a particular statute that allows you to bring a lawsuit. Now, how does that dovetail with the APA? If you notice in Section 703 of the APA, that talks about the form and the venue of the proceeding, it says the form of proceeding for judicial review is the special statutory review proceeding relevant to the subject matter in a court specified by statute. So basically what the APA does is it provides kind of whatever it needs to provide that you can't otherwise find in the context of the statute. If the statute says you have a cause of action, you have a cause of action that you can file in a particular court, say the D.C. Circuit, and the standard of review for the D.C. Circuit in the context of that cause of action is substantial evidence, then you've got a lot of the information that you need in the substantive statute, and the APA doesn't do a lot for you. On the other hand, if the statute doesn't say anything in particular, then the APA's cause of action, its gap-filling statute, may very well provide everything that you need. So you have to use both the substantive statute and the APA together to try and identify the relevant approach that you may want to take in a particular case. Now, the next thing that I wanted to talk about is causes of action for money damages. The one place that in a lot of ways the doctrine of sovereign immunity is not yet largely dead, because as you note, these APA provisions, I mean, they really open up the door to litigation against the federal and state agencies. But it doesn't open up the door with respect to money damages. So what's really left as far as the ability to sue the federal government and state government for money damages are particular statutory provisions that take a couple of different forms.